My name is David Giza, and I'm here with April Donahauer to discuss a case that she recently argued in front of the Court of Appeals for Veterans Claims, Geraldine Lorio versus Dennis McDonough. April and I have recently returned from scenic Grundy, Virginia, where the court heard this case at the Appalachian School of Law. April, I know there are a number of facts and benefits at play here. Could you give us a brief overview of the history of this case?
Sure. So first is the Survivor's Benefit Plan. This is an insurance-style plan that retired service members can pay into so that their surviving spouses have a source of income after their death. The other benefit at issue here is Dependency and Indemnity Compensation. That's a VA benefit, unlike SBP, which is administered through DoD or Department of Defense. DIC is a VA benefit that is awarded to surviving spouses, typically based on a service-connected cause of the veteran's death. So Mrs. Lorio was eligible for both benefits here, and this case really surrounds what happens when a survivor is entitled to both, because for a certain period of time, survivors weren't entitled to receive the full amount of both SBP and DIC. So if there was a later award of DIC, it would create an overpayment of the SBP benefit.
All right. So the board here denied Mrs. Lorio's appeal about the withholding of DIC benefits, finding that VA had the authority to do so, that all legal requirements were met, and that these benefits were properly assigned to the Department of Defense to cover the SBP overpayment. What was CCK's argument to the court about why this was wrong?
We argued that VA did not have the legal authority to take Mrs. Lorio's DIC and pay it to DoD to cover that SBP overpayment that I mentioned earlier. So Mrs. Lorio started receiving SBP pretty much immediately after her husband died, and then was later found entitled to DIC. What should happen in that case, we argued, is that DoD is responsible essentially for collecting the SBP overpayment. But what instead happened here was that VA withheld the retroactive DIC award and gave it to DoD to cover that overpayment. And we argued that that was prohibited by law because Congress has said that VA benefits can't be withheld and paid to another agency that way, to cover a debt to another agency. So in and of itself, the withholding was wrong. Also, there are some procedural protections that are in place before an SBP overpayment can be collected. So even setting aside the illegality of the withholding, there had to be some kind of notice and opportunity to challenge the amount. Really at the root of all this was that there still has not been a detailed accounting of how the amount of that overpayment was calculated.
I see. And of course, we know that VA disagreed with these positions. Specifically, we know that VA is arguing that when Mrs. Lorio applied for SBP benefits, she authorized the VA to withhold and transfer her future DIC benefits to the DoD. That application form, by the way, was not actually part of the evidence the board considered here. We also know that VA argued that the notice requirements we highlighted were not relevant or applicable to Mrs. Lorio's case. And we know that VA argued that, ultimately, this is not even an issue for the Veterans Court to decide because, in their view, all the benefits here were administered by the DoD, not VA. April, I know that we disagree with VA's arguments for several reasons. But what do you think the court is likely to do here?
Well, like you said, David, the VA counsel really focused on this 1994 application form at the oral argument and basically didn't challenge the legal argument that we made in the briefs that the relevant statute prohibits what happened here. The court registered some skepticism at VA's argument about that 1994 SBP application form, not only because, as you said, it wasn't part of the record before the board, And the background rule here being that the court generally is confined to looking at evidence that was already before the board, but also because, as we argued, that form didn't tell Mrs. Lorio anything about the consequences of what she was signing to her future ability to receive DIC, to get the due process requirements we argued that she was entitled to. And the court seemed to be somewhat receptive to both of those arguments, and they were especially concerned about this form not having been before the board. So it seems like they will agree on one or the other of those arguments.
All right. Well, thank you very much, April, for your thorough explanation of this case. And I hope this has been informative for all our viewers. Thank you very much.
Thanks.